you. hate speech.
Good afternoon. This is the sentencing of the Parkland school shooter. I'm Janine Stanwood with our legal analyst, Gail Levine. The judge is hearing some pending motions right now, so let's take a listen.
I saw the motion to require the state's rebuttal, but I was told it wasn't filed. So I'm not prepared to argue the defense 2 motions. They were just filed. I wasn't expecting it to be heard.
Where's the motion? I'm sorry, I didn't mean to interrupt. Where's the motion, Ms. Curtis, that you said you were going to file last week by Thursday so that we would have it heard today?
That's DMIL 16, just the reason we didn't file it if there was a pending motion that would have made it inappropriate to file this motion prior, but I did share it with the state.
I understand.
I shared it with the state yesterday. And the motion to strike the state witness, it's a pretty straightforward motion, Judge. They listed a witness a week ago Friday, 2 weeks into our mitigation case. They will not make him available for deposition until this coming Friday, which leaves absolutely no business day in between our deposition of this witness, who we have no idea what he would testify about, and the state's rebuttal case, leaving no time for us to litigate any issues with regard to his testimony. So we are prejudiced from this. It's a late disclosure. The documents they gave him were documents they've had in their possession for 4.5 years. It's definitely intentional, and it's substantial. He's an expert.
I don't know. I was just asking a question about the motion that was supposed to be filed last week. So what are you all asking me to do?
The motion in limine on the swastika. The notice we had yesterday and then other motion that at 3:30 we got this motion yesterday afternoon, motion to require state's rebuttal. And in that email, the defense said that they wanted to hear it Tuesday. So that was, since it wasn't filed yet, I wasn't expecting it was going to be heard today.
Okay, so rather than sit here and just go back and forth on when things were filed and who can be ready for what, would it be more prudent to just have these heard tomorrow, even though we're all here?
I'm ready, Your Honor. If the court wants to do the one today or all tomorrow, whatever the court's pleasure.
Okay, so we have 3 motions. We have I'll call it the Swastika Motion, which I'm very familiar with. I assume both sides are familiar with that motion and the merits of it because it's been argued many times. And who's going to be the point person from the defense?
I will be, Your Honor.
All right, are you ready to argue that motion?
Yes.
And state you're ready to argue D306?
Yes, Your Honor.
I'm sorry, not D306, excuse me. SF222 in response to D306.
Correct.
Okay, is there anything that you'd like to add to your written motion?
No, Judge.
There's no argument?
Oh, and yes, there's oral argument. Yeah, I thought you meant in addition to what I filed.
No, anything at all that you would like to add? In other words, any additional argument, case law, anything that you would like to add, you may do so now.
Okay. Thank you, Your Honor.
Sure.
I do want to, I'm sure the court has seen the defense exhibit. They filed a timeline of the history of this motion, which was originally filed back in January of 2021. The motion was originally for the admissibility of hand-ed swastikas on the defendant's boot that he was arrested with after fleeing the scene, and also recovered on the AR-15 magazine. The motion has since evolved and now includes hate speech that was discovered and contained in the defendant's social media. When the original motion was filed, obviously the defendant had not pled yet, and the basis for that motion for the state's purposes was identity. Once the defendant fled in October of 21, that issue obviously was evaporated, identity no longer an issue. However, the state maintained the filing and wanted the court to rule on it in the future if it became relevant to the state in the penalty proceeding. And that would obviously be dictated by whatever the defense mitigation was during their presentation. So we've now reached that point where the defense has put on their mitigation, we're ready for rebuttal. It is at this point that the state would argue the motion is right. The defense has been complaining that the state did bring up the motion and they didn't get a ruling, so they couldn't question during jury selection issues about hate speech or swastikas. They had no problem asking about anal abuse. They had no problem asking about white privilege. They knew what records that they were going going to be admitting. We did not. They admitted records from the school board, which is Defense Exhibit 92, and records were introduced and carried on, and that is Defense Exhibit 78. Both of those documents contain language about the backpack that this defendant wore with the swastika drawn on it, and also the phrase F and words. Again, we didn't know who was being called or what evidence was being admitted, as this court saw maybe the night before, sometimes the morning of. So the defense knew what records they were admitting. They made the strategic decision not to question the jury about swastikas or hate speech. They cannot now come to this court and complain or blame the state when they were in control of the evidence that they were going to admit. They had the opportunity to pick and choose their evidence the same way they had an opportunity to pick and choose what to talk to the jury about. So now, based on the fact that those records are in evidence and that documentation regarding the swastika and the racial slurs there, any prejudice has now evaporated. And it's in evidence. And there were plenty of records. They didn't have to admit those records. They could have chose bits and pieces, but they didn't. They put them in evidence. They've opened the door, and now the state is going to march through. The photo of the backpack is what the state is seeking to admit. It is a photo of the defendant wearing the backpack, and you can clearly see the language that's written on it and the swastika that's drawn on it. It is to admit in the state's case a rebuttal to show he's not a victim of bullying, that anyone who walks around with that kind of language and symbols on a backpack is clearly provoking, and which also lends itself to the diagnosis of the state's experts, which is antisocial personality disorder. And since the state plans on putting on testimony regarding that, and that is also to rebut the defense experts' diagnosis of neurodevelopmental disorder related to prenatal alcohol exposure, along with alcohol-related neurodevelopmental disorder by the defense. I'm sure this court recalls Dr. Brandon's lengthy testimony on July 7th, and he testified that social media searched by this defendant that covers racism, animal abuse, hatred towards women, Hitler, porn, Black Lives Matter, is all important to this diagnosis because it is a window into the defendant's mindset and hatred towards others, which is a critical piece in making that diagnosis. And for some reason, the defense keeps isolating words like Holocaust, Nazism, and Hitler, and argues because those terms don't lend themselves to any diagnostic criteria with antisocial personality disorder, they shouldn't commit. This is the totality of the search. The defense doesn't get to pick and choose what experts use in order to come to their diagnosis. This court heard that very, very long list of terms that Dr. Brandon read into the record. This wasn't the defendant doing research for a history project. This was clearly displaying his contempt for people, his hatred for people, his disregard for the rights of others, aggression, so on and so forth. All the checklists that goes towards diagnosing antisocial personality disorder. It's a multifaceted defense, and again, the defense doesn't get to dictate what social media the state's experts can and cannot use to make their diagnosis. They are not the psychologists, they are not the psychiatrists, they are not the experts. So again, the defense has opened the door by admitting the records, the documentation of the swastika and the racial slurs, and then for that reason, they cannot now claim prejudice. The state should now be permitted to admit the photograph of the defendant wearing the backpack with those items on it, the boot that he wore, photographs of the boot he wore on the day of the shooting, and the etched swastika that's on the AR-15. The state has as to social media, obviously the state has a right to rebut any defense mitigation. Both defense experts testified as to the diagnosis of MD-PAE and the ARND. The state's rebuttal is that the defendant should be diagnosed with antisocial personality disorder. That hate speech contained in the searches by this defendant is relevant and certainly part of the expert's overall diagnosis. So, Your Honor, for those reasons, everything that's in the state's motion 222 We incorporate all the other arguments that this court has heard, and I know it's very familiar. We would ask that we grant the state's motion for admission of all those items. Thank you.
Defense?
Good afternoon, Your Honor. The defense has had opportunity to review the state's motion at Sept 222. Your Honor, and it's our position that the defense has not in fact opened any door. On September 1st of 2022, the defense called witness Carrie on. There was some documentation that she had maintained control and possession of since Mr. Cruz was no longer a student at the school for fear that the school board would have destroyed it. So she kept it. She turned that over to the defense during her deposition, and we wanted that documentation to be admitted during her testimony. We spoke with the state and asked that the swastikas be redacted from that document. They were in disagreement with that, and we had arguments as to that. We asked the court to redact the swastikas in light of the fact that we had not received a pretrial ruling on SF 202. I then went through the procedural history of that motion. I don't want to do that again, so I'm asking if the court will accept the arguments and the timeline that I provided on September 1st of 2022. Over the objection of the defense, the court allowed the state, indicated that the defense would have to submit all of the documentation with all of the information, specifically the swastikas, that we asked to be redacted. So it was admitted. It was admitted after we had requested that that information be redacted, and without the court giving the defense the benefit of a pretrial ruling like we had requested before the jury was seated, before General Gordire was taken. Briefly, Judge, even if the court is going to continue to expand the ruling that you made on September 1st of 2022, this court still has the discretion to admit evidence and to limit evidence, especially if it's prejudicial, overly prejudicial, or cumulative. This is a thinly veiled attempt by the state of Florida to introduce bad character evidence. They want to get up there and say, did you see this social media post? Did you see this? Did you say that? Dr. Brandon testified that this information was necessary because, meaning the social media, because it showed a persuasive pattern of disregard for the rights of human beings. What the state did not elicit from that witness was that Mr. Cruz had done 8,700 searches, and only 430 of them contained the content that the state is seeking to admit. So it's not a persuasive pattern. Perhaps that's an argument that we need to make on cross-examination, that the court does need to take into consideration, since you, in essence, have already granted SF 202 on September 1st over the objection of the defense, that information can be cumulative and it can be overly prejudicial, and the state will be trying to make this a feature of the trial. Had the court ruled on this motion prior to jury selection, we would have voir dire on those particular issues. So in light of the fact that the defense was unable to voir dire on those issues, despite numerous requests to have the court rule on the state's pretrial motion, and it also would have impacted the presentation of our mitigation in this phase. The court, that we would also say that if the court is inclined to allow the state to get into this material, a door which we did not open, the door was opened by the court by allowing Ms. Carry-On's documentation in over the defense of the objection, over the defensive objection of the defense. The court still has discretion to fashion an equitable remedy and to limit the amount of this information that is moved into evidence. If the court is inclined to grant the state's motion, SF 222, based on the fact that the defense did not have an opportunity to voir dire on these specific issues because the court had not ruled, we would also be moving for a mistrial. And I would just adopt all previous arguments, Your Honor, related to this particular issue, specifically what was argued on September 1st, 2022.
I'm sorry, I missed the last part. You're moving for a mistrial for what?
Well, if the court is going to be inclined to grant SF 222, which is the state's motion to allow in the swastika, the hate speech, all of that information, this is a similar motion that the state had filed before Mr. Cruz had pled, and then had renewed it after Mr. Cruz had pled, and the defense had requested numerous times for a ruling on this motion so that we could fashion our voir dire and how we would anticipate presenting our mitigation. It would be impacted by this court's ruling. So if the court is inclined to grant this motion over the defense objection, we would be, again, like we did on September 1st, 2022, we're requesting this court grant a mistrial because the defense has directly been prejudiced by its inability, because of the court's failure to rule on this motion, to voir dire the jury members on these particular issues.
I'm sorry, just make a quick distinction.
Sure.
Ms. McNeil is referencing records that were removed by Ms. Young, which is the Defense Exhibit 78. They did not reference Defense Exhibit 92, which is from the school board, which has clearly written there on threat assessment about the backpack. So that door has been opened.
But State, just so that I'm clear, the additional arguments you're making, in other words, you're not substituting these arguments for the arguments previously made that these things, I'll call them things, like the swastika and the language and the searches and those things, your previous argument was that those things are probative of the diagnosis of antisocial personality disorder. You're merely substituting your argument, saying, or not substituting, but supplementing your argument, now saying not only are those things true, but also the defense opened the door and that these items were contained within evidence that was put forth by the defense in their case.
That's correct.
You're not substituting an argument, you're supplementing.
Adding to.
And that evidence that the defense sought to admit was the documentation from Carry On. We had requested that the court redact the prejudicial information that was contained within those documents, and the court denied that request. As well as, so the court essentially allowed that information in evidence, so the defense was in a position where they either hide evidence from the jury or we give them a complete picture. We had no other choice because we need to be honest with this jury so that they have all the information they need in order to make a decision. The remainder of the school board records were in fact admitted.
Okay, first of all, I didn't keep anything out of the school board records. I specifically asked you all what you wanted out of the school board records, and you didn't know. The state was the one that had to tell you that those prejudicial items were within the school board records. So how could I possibly know what was in them if you all didn't even know what was in them? And you were going to take the time to try to go through it at a later time, and you wanted me to admit them with the caveat that you'd be able to go through and figure out which items you thought were prejudicial, and then you never brought it up again. So I don't know how you could be blaming that on me when I don't know what was in them. You had 5 boxes of records. When I asked you all what portions of those records you wanted out, you didn't know.
So Judge, after the court had ruled on the documentation, the composite for Carry On, which allowed in the swastikas, the defense was in a position to make a decision about whether or not we should move in all of the evidence because we didn't want the jury to believe that we had misled them. So when the court allowed the swastikas to be admitted in through Carry On over the objection of the defense and denying our request to have that particular information redacted, we made the decision that we had to admit everything because of the position that we had been placed in. And the court still is required to make a 403 analysis on the additional information that the state intends to see admission of. So we would ask that the court exercise your discretion and apply that 403 balancing test.
Judge, I just point out that this was a strategic decision by the defense to admit all of those records. Nobody made them, the court didn't make them, they decided to put them all in, they opened the door, and now the state can go through it.
Because I'm going to have a written order by tomorrow.
Judge, if there's any way, if the court is in contemplation of granting the state's motion, that they could specifically allow us or advise the court as to what they tend to admit so the court can make a determination if you in fact do need to limit the amount of it so that it's not cumulative or overly prejudicial.
I don't know what you're asking. You want me to order the state to tell you in advance what they're going to put in the rebuttal case?
No, specifically the items that they refer to in their 222, is that the court is going to exercise your discretion to try and limit the amount of that information so that it's not cumulative, so that it's not overly prejudicial. The court doesn't have any way or ability to make that determination, so we would ask that the state advise the court and the defense what information they intend to introduce that supports what they have in SF 222.
Okay, well, their wherefore clause on page 5 sets forth exactly, and I'm assuming that you're not asking to put any more or any less than what's indicated in your motion, which says firearm magazine hand etched with swastikas on each side of the magazine, loaded in the AR-15 firearm used in the shooting and left at the scene. 2, the boots worn by the defendant when he was arrested approximately 1 hour and 20 minutes after the shooting began, which has a hand-etched swastika on the right boot. 3, the photograph of the defendant's red backpack depicting a swastika and racial slur. And 4, hate speech contained in the defendant's social media.
So thanks for the clarification on that, Judge. I think that my argument needs to be more specific as to number 4, which is the hate speech contained within the defendant's social media. There's over 400 potential searches that the state could be relying on. So we would just ask that the court seek some direction from the state so that you can exercise your discretion to make a determination if it's going to be cumulative, overly prejudicial. The court has the ability to limit evidence. It's within your discretion to do that. Thank you.
Do you have any idea of whether you intend to use all, some, or? Sure. And you can let me know at a later time also.
Your Honor,
Yes.
we will provide a list at this time. I would tell the court it's not to be a feature of the trial, but as far as there's a timeline progression, and, we want to make sure people, what is relevant and, it's relevant to whoever's testifying. So we provide it to the court, to the defense, but I can't do it right now.
Okay, when can you have that prepared?
In the next couple of days.
Okay. Now, as far as these other 2 motions are concerned, obviously I would like to hear them before next week.
Judge, we would ask if we can come back tomorrow because the court's ruling on DMIL 16, if the court is inclined to limit the state to certain experts, then, otherwise we'll be preparing motions in limine on experts that may never be testifying and would be asking for additional hearing time to hear those motions in limine. So it's sort of in other words, it's like one depends on the other. It's a progression. So once we know the court's ruling on DMIL 16, then we'll know which of these experts we need to file motions in limine regarding.
State, I don't need to put you on the spot, but if I give you like 30 minutes to look this over, can we do it this afternoon, or do you need me to reset it? I am putting you on the spot. It's not my intention, but
It's 3 o'clock. Okay, Rose?
sure, today? I mean, I assumed we were going to be here all afternoon, so that's fine with me. I appreciate that. And if there's anything else, you all can get together before 3 o'clock. We'll recess till 3, and then we'll come back and I'll hear these, okay? All right, thank you.
Okay, so Gail, it sounds like the state wants to, well, first of all, let's talk about the first thing that they spoke about, which was the state wanting to admit some evidence that they say will go along with their rebuttal witnesses to say, listen, instead of fetal alcohol spectrum disorder, instead of the shooter being bullied, he was the bully. He actually had antisocial personality disorder.
Correct. That is a psychological disorder, and some of antisocial personality disorder leads to psychopathy, which is what they are trying to say. He's not just an antisocial personality disorder. He is the worst of the worst, the one that can't be treated, the one that, if let out or even in prison, would wreak havoc.
And so some of the things that they want to admit are, there are 4 things, according to this motion that
Correct.
was filed. Okay, so firearm magazine, hand-etched with swastikas, boots that were worn while he was arrested after the shooting, which also had a swastika on the right boot, a photograph of his red backpack with a swastika and a racial slur, and hate speech contained in their social media. The defense is saying, hey, this is too much, but didn't they already allow evidence that showed some of those things?
So they made some strategic decisions throughout the case. They wanted the drawings that the defendant had done to be put in, but they wanted the judge to erase, in effect, redact the swastikas. The judge chose not to do that at that time, so they could have not put in the drawings and just spoken about them.
Right, had the witness, that teacher, speak about what she saw.
Correct. Or they made a strategic decision and they put the item in the way it was.
And so the state is arguing, hey, the door's already been open.
Correct.
This should be allowed in.
Now listen, the jury has not seen the firearm magazine, and nobody's spoken about the firearm magazine. In fact, that has not been put into evidence by the government because the judge wouldn't allow that because of the swastikas on it. The boots were not put in because of the swastikas. The backpack, there is a picture already in, again, not by the state, but by the defense. They put that in. So what the state says is, you open the door. What we used to say is, you open the door and we drive our plane right through it. So the door is open, and it doesn't matter whether it's open just a crack or it's open wide. We want to be able to say, yes, this swastika, this bad language that is part of his antisocial personality disorder, the fact that he can't conform to the norms of society, that goes to his diagnosis. And their expert has already been deposed and testified in front of the judge that these items do go to his opinion.
So it sounds like there was a little negotiating. So the defense said, listen, would you limit it? Would you be able to tell us what you state, what you would agree to not have put into evidence?
Well, I think that they got a read from the judge that the judge is going to do what many judges do, and we call that split the baby. So the judge isn't going to give them probably everything, probably not the magazine, because nobody's spoken about the magazine, probably not the boots, because nobody's spoken about the boots, and maybe the judge is going to give the picture of the backpack and maybe some of the social media. And she was saying, how much of the social media do you need? Can you give me a list? I know I'm putting you on the spot, but can you give me a list? And the prosecutor said, Judge, I can get you a list. I want to show a progression of it, so I can get you that in 2 days. That tended to me to seem that she was more or less going to rule almost with the state.
Right.
Give it some, but not a lot. And in doing that, I think that if she does that correctly, because what they're talking about is that prejudicial analysis. This isn't about a hate crime case. This isn't about a kid that did this because he hated Jews or he hated blacks. He did it because he is a sociopath and he wanted to be a mass murderer. So this is just a portion of his diagnosis. It's not his full diagnosis.
So there are 2 other motions that will be brought up. They're going to take a break until 3 o'clock, and this just in, so forgive me if I'm kind of looking along. Christina Vasquez, who's in court right now, she just sent me sort of a screenshot. She got this in-person copy just obtained, an order denying the defendant's amended motion to disqualify. So this was the big hubbub from last week when there was that argument argument between the lead defense attorney and the judge, basically saying, listen, the judge went too far in her criticism. Last week, after they rested without warning, they produced a motion to disqualify, saying my client can't have a fair trial.
Right. So I think what some people that aren't courtroom watchers or aren't in the courtroom, like lawyers every day, judges yell at lawyers a lot at sidebar when the jury's not there, and sometimes even when the jury's there.
You are a veteran prosecutor,
and
I've
had the wrath.
Yeah.
I've had the wrath. For whatever reason, I provoked the judge in some way, not intentionally likely, but I have been called out, so to speak.
So this isn't rare. Filing a motion to disqualify a judge, that's something that happens?
It does. It happens. I think it doesn't happen every day. A lot of times if the judge is riding you, you'll maybe file the motion in order to say, Judge, you're riding me, and it's getting to us, and we need to know that. But in this case, the way it happened was all outside the presence of the jury. And I think looking at the transcript, which I had the opportunity to do, and also looking at the motions, what I think set the judge off was the sort of dishonesty that the public defenders gave before the jury walked in. The judge kept saying, for your next witness, make sure they don't talk about these privileged items. Those privileged items by law can't be spoken about. And she said to one of the public defenders, calling him by name, she said, make sure, is that your next witness? And he said, it doesn't apply.
So basically, he didn't say, we're not calling any witnesses, but they weren't totally forthcoming. They don't have to. And by the way, attorneys don't have to tell a judge what their next move is.
Only if the judge asks you. And what happened was, that's sort of like saying, I swear to tell the truth, the whole truth, nothing but the truth, and you don't tell the whole truth. So when the judge said, your next witness, really the correct answer would be, Judge, there are no witnesses that are going to be testifying to this because we're going to rest today. And I think that she was sort of shell-shocked that she had set out the next week of people's time. And the judge is concerned about the jurors' time. She's getting paid. The public defender's office is getting paid. The prosecutor's getting paid. But the jurors are missing their lives. And she's very, very concerned about their dedication, and she's appreciative of it. And now she looks like a fool because they're going to walk in and she's going to say, oh, by the way, no court today.
Right.
And
Defense
she's not going to be
the case.
Yeah. And so no court today, and we're not prepared. And I've been twiddling my thumbs all day to tell you that you can now go back to your week. So she didn't want to be put in that position. I understand that she didn't want to be put in that position. But I think the judge pretty much sets her opinions on the table. You saw it today. You know, she sets the state, you know, I don't want to put you in this position, but you got 30 minutes. Can you give it to me in 30 minutes? I don't really like to be told what to do in 30 minutes, you know, like big motions, but they're going to try and do it. Try and accommodate the judge and accommodate the time.
So after all of the uproar about what happened last week, the defense unexpectedly resting its case, the defense then filing this motion to disqualify the judge. We have just learned moments ago that the judge ruled that she has denied the motion.
So one thing should be made clear. The judge could not have gone on to the other motions unless she had put her answer in writing.
So that was something that was done in writing before we saw what we saw.
There's no argument allowed. It's done totally in the pleadings. The pleadings are either sufficient or insufficient, and just yelling at the defense attorney and not having something more than that is legally insufficient pursuant to the case law.
So there you have it. They will continue. They'll be back at 3 o'clock to hear whatever these next two motions are, and we'll be there with you as well. We'll see you at 3. Good afternoon. This is the sentencing of the Parkland school shooter. I'm Janine Stanwood with our legal analyst, Gail Levine. No jury in the House today, but the judge is expected to hear another motion, so let's listen.
Whenever you're ready.
I don't mind if they're related, so I don't mind if we just argue together.
Okay. What was the last thing you said?
I said I intend to argue both of them together because they're related.
Okay.
If we decide to like to do the same, that's fine.
Whenever you're ready.
Okay. Judge, I'm not going to take up too much time because most of this is all spelled out in these motions. The motion in limine to require the state's rebuttal to address mitigating circumstances presented and to limit cumulative rebuttal evidence. There's sort of two aspects to that. One is that rebuttal is just that. Rebuttal is evidence that proves or shows up that what the opposing side said is not true. And now, in a capital case, the state's rebuttal can also argue for the diminished weight of mitigating circumstances, but the rebuttal case is not an opportunity for the state to simply present evidence of Mr. Cruz's bad character, and it's not an opportunity for the state to present evidence
in aggravation that it chose not to present during its aggravation case so that it could present it after the defense has had their opportunity to speak. The rebuttal has to address mitigating circumstances raised by the defense. And I list on pages 2 and 3 the mitigating circumstances that were presented. Most of these came from our Rule 3202 notice, not all of them. And then going to the experts, and this, the court remembers the litigation that we have with regard to the number of state experts that could evaluate Mr. Cruz. The defense called at trial a speech and language pathologist, Dr. Shamika Stanford, a pharmacologist, toxicologist, Dr. Susan Scully-Danziger, Dr. Paul Connor, a neuropsychologist, and Dr. Kenneth Lyne-Jones, who is a medical doctor, albeit an expert in fetal alcohol spectrum disorders. The state has listed and is presumably intending to call, although we don't know this, we just haven't heard anything to the contrary. They have two neuropsychologists, 3 forensic psychologists. One of those is the same person. In other words, one is a neuropsychologist and a forensic psychologist. A psychiatrist, and then a psychologist. With a couple of exceptions, and we're not entirely clear on Dr. Gilmet. He is actually, I think, set to be posed again tomorrow. His referral question initially was to rebut any claim of intellectual disability, which was not raised as a mitigating circumstance. So whether he has anything else to say or not, we don't know at the moment. But, and then Dr. Ferguson, which we'll talk about in just a moment. The rest of the doctors, Dr. Denny, Dr. Scott, Dr. Zapp, Dr. Brandon, all have arrived at the exact same conclusion, that Mr. Cruz has antisocial personality disorder, borderline personality disorder, and is malingering with regard to certain symptoms. So irrespective of whether any or all of their testimony does in fact rebut a mitigating circumstance, certainly to have 4 doctors come in to testify to the exact same thing would be unnecessarily cumulative, and under Rule 403 the court can limit that. We did not call a psychiatrist, so with respect to Dr. Scott, although he is admittedly the only medical doctor that the state has listed, so if he wants to try to rebut medical testimony, that's understandable because he's the only one that could. But to have 3 forensic psychologists all testify to the same thing is unnecessarily cumulative. So we're asking that the court limit the state's rebuttal so that it's not cumulative and that it actually rebuts. And I understand that it's going to be a little difficult here now to decide what is rebuttal and what isn't, and who should testify and who shouldn't, but at the very least, to allow the state to have psychologist after psychologist after psychologist come in to all say the same thing would be unnecessarily cumulative, and it would, frankly, just waste everyone's time. So we're asking that the court limit. With respect to Dr. Ferguson, we have a couple of issues with respect to him. And I'll address the motion to strike before I come back to our arguments on his rebuttal. So on September 9th, 2022, that was not this past Friday, the Friday before, 2 weeks into the defense mitigation case, the state listed this witness, Dr. Christopher Ferguson. They gave us a list of the materials that he reviewed. What he reviewed basically are the psychological evaluations that were done on Mr. Cruz throughout his time at the Broward County School. So these are documents. These evaluations have been in the state's possession since at least May of 2018, because that's when they were turned over to the defense. They gave him materials to review that they've had 4.5 years, and if they wanted him to rebut something as a result of that, then they could have listed him years ago. Or at least when they listed their other experts. He is an expert witness. He's not a records custodian. He's not just a fact witness. He will be able to render an opinion, so it is a substantial discovery violation for them to give us this after we have already, not just after the trial started, but after 2 weeks into our mitigation presentation. Additionally, Judge, the prejudice is, there's a few things. One, we may have done something slightly different in our mitigation presentation had we known this witness was going to testify and had known what he would testify about. Also, Judge, depending on what he tells us in his deposition, we don't know whether we'll have enough time to prepare an effective cross-examination. They could theoretically call him first on Tuesday morning, and we may not be ready on that. And third, because they won't make him available to us until this coming Friday for deposition, that leaves absolutely no business day in between our deposition of this witness and the commencement of the rebuttal case, which means that there is no time for us to litigate any issues regarding the relevancy or prejudicial nature of his testimony. All we can glean from this witness's experience is that he may be testifying about a connection between playing violent video games and committing violent acts. That was never raised in mitigation. So we have absolutely no idea what this witness would testify about, and by the time we find out, it's going to be the last business day before their rebuttal case. So we're asking that the court strike this witness as a discovery violation, and if the court is not inclined to do that, the court can fashion another remedy, which would be to either make the state produce him sometime earlier this week for deposition, or the court can set aside time on Tuesday and order that the state not call him prior to giving us an opportunity to litigate the issues with respect to his testimony. And again, as I said, if he is going to testify that the research does not support any connection between playing violent video games and committing violent acts, that was not ever raised as a mitigator. It's never been argued by the defense. No expert witness on the defense testified to that, and so it would not be relevant mitigate or rebuttal. Thank you.
Thank you. State?
Your Honor, I'll begin with Dr. Ferguson. First of all, the defense, so there's a motion to strike State Witness D-334, but in their motion in limine D-MIL 14, they speak of Dr. Ferguson, and I just want to...
You said DMIL 14. Do you mean 16? Or do I need
Did
to...
it change?
The copy that I sent you was had it wrong.
Oh.
The one I sent you yesterday.
Oh, I copied, the one they sent yesterday said 14, so I guess it's 16.
But
Everything else is...
It's the same motion. I don't need to pull, but, okay, I just wanted to make sure I'm on the same document that you were talking
You
about.
say 16? I didn't know what, okay, thank you. So in DMIL 16, the defense in paragraph 16 addresses Dr. Ferguson. And he indeed is an expert in violent video games, social media, and the commission of acts of violence. And the defense says in this motion, it's a little bit different than what they argued in their motion to strike, is that the testimony regarding Mr. Cruz playing violent video games pertained to his unhealthy obsession with playing video games and his inappropriate responses to being prevented from playing them or for losing at his video games. Contrary to what's been argued by the defense, what has been presented, it repeatedly began to come up in the defense case about violent video games. Mr. Gold on August 31st testified they seemed to play a lot of violent video games, and that's at page 7548 of the record, line 4. He on 7557, strike that. That was about Zachary coming over to playing violent video games with Rocky. Mr. Vesey on 9/1 was asked a question and the record site is 7863. On line 18, the question asked was, did you know about his obsession with video games? And the answer was, through his mom and through our support staff meetings. And then the answer goes on, but it doesn't address until at the end of it about him punching holes in the walls at the home because he would get frustrated with the video games and things of that nature. And then the same day, Ms. Carrie Yon, she, from the teacher from West Glades, who appeared, as you might recall, on Zoom, and I think she was in her husband's office, I think in Palm Beach at the time. She testified at page 7786 on lines 3, reading from a record that she had produced. The defense had her read this into the record. I quote, "I do not feel that he understands the difference between his violent video games and reality." So the defense, contrary to their argument today, has clearly put his obsession with violent video games into evidence as interfering with his ability to tell the difference between reality and the games themselves. In their motion via MIL 16, they say the evidence came in pertaining to his unhealthy obsession. So clearly, that can be a mitigating circumstance, that he had an unhealthy obsession with violent video games. It's clearly a mitigating circumstance. So all of this was August 31st or September 1st of this year. Our records, I'm told that we actually, not that a day matters, but I believe we listed Dr. Ferguson on September 8th, 7 days. The defense says 8 days. I'm sure that doesn't matter. The state has, it's not that we're preventing him from testifying. He has a busy schedule, and there was negotiations, and there was emails exchanged between the defense and the state and Dr. Ferguson, and that was the first time that he was available was the Friday. We have no objection to not putting him on the first day of our presentation so that they have that extra work day if they deem it necessary. But a motion to strike a witness, it's really, they're asking for a Richardson hearing. It's premature. They're going to depose him, so they'll have an opportunity to depose him. The defense, the state has listed him, so, and the argument about the psychological records, that it never had come up before that the defense was going to use violent video games as an unhealthy obsession by their own admission, as a mitigating circumstance, or that he can't tell the difference from reality and a violent or a game itself. So it clearly came up during the trial. The psychological records that were given to him were just so that he knows what the defendant was diagnosed with as a child. These are psychological records from the school, so it's just a record so he knows what he was diagnosed. As to whether or not that will make a difference as to his opinion, the state anticipates that his opinion is that there is no causal relationship between violent video games and killing, and that will be about the extent of his testimony, which the defense will have ample opportunity to take his deposition. So if I can move on now to the rest of their motion, on their motion in limine, I'd like to point out, first of all, the defense has just told you that the list of mitigating circumstances that they intend to use that's contained in this motion is not exhaustive. So the state still has to guess as to what the mitigating circumstances might be. But what they have provided to us in this list, and I just want to highlight some of them, because they go to his mental health defense, such as has neurodevelopmental disorder associated with prenatal alcohol exposure. Now, as their witnesses, their experts testified, that was a DSM diagnosis. Somehow the defense argument is that all we can do in rebuttal is have a witness say, no, that's not the diagnosis. Clearly, that's not an accurate statement of the law. They don't cite any cases that say that. They have put the defendant's mental health in dispute. It is an issue. The state can then present different diagnosis under the DSM, which the state intends to do as to antisocial personality, borderline personality, and that he malingers. I'd also like to point out that the defense also listed impaired social skills, memory deficits, motor function delays, impaired motor skills, neurological impairments, multiple deficits in adaptive functioning, brain damage, executive functioning deficits, independent functioning deficits, cognitive deficits, intellectual deficits, central nervous system abnormalities, developmentally delayed and diagnosed with ADHD and OCD. Now, the defense puts in this list intellectual deficits, and then in paragraph 14, they say the defense did not claim either in its notice, 3.202 notice, or its actual mitigation presentation that Mr. Cruz is intellectually disabled. Now, they claim that he has an intellectual deficit. Now, whether it's deficit or disabled, the state is able to rebut that. The state is able to present rebuttal testimony. This argument should be immediately dismissed. Excuse me just a moment. If you recall, Dr. Jones, the defense expert, pediatrician, testified that FASD, fetal alcohol syndrome, caused the murders, which was a very open-ended conclusion that he made. The defense in footnote 2 states that they did not present evidence regarding 3 mitigating circumstances, which include 1, the defendant was under the influence of extreme mental or emotional disturbance. 2, capacity to appreciate criminality of his conduct or to conform his conduct to the requirements of law was substantially impaired. And 3, the diagnosis of acute psychosis immediately after the incident. Accordingly, quoting the defense, any rebuttal of those mitigating circumstances would be improper. When the defense presents mitigating testimony that FASD caused the murders, it encompasses the defendant was under the influence of an extreme mental disturbance or emotional disturbance. That clearly is encompassed. The capacity to appreciate the criminality of his conduct or to conform his conduct to the requirements of law was substantially impaired. That's encompassed when you say FASD caused the murders. So whether those exact words are addressed, that still needs to be rebutted by the defense if we're able to. And the defense wants to hide the defendant's malingering. Again, the defense has put his mental state into issue in this case, and as the defense admitted in footnote 4, where they said, like any other rebuttal evidence of Mr. Cruz malingering must relate to him malingering regarding a condition that was raised as mitigation in the defense case in chief. So that's ridiculous. I mean, it's a ridiculous argument. So he's lying about one condition, but we can't bring that out to show that he's lying about testing with another condition. And the defendant doesn't say, okay, my lies are only directed to the ones that the state is interested and not the defense. It just doesn't make any sense whatsoever. And the defense admits that, and what they're concerned with is that his claim of hearing voices would be improper rebuttal because the defense did not present testimony or any way that he hears voices, in other words, psychosis. And quite frankly, they admit that their own expert is the one who's testified that that they do not believe he hears voices, and that he believes the voices are simply his own negative thoughts. How the defense could say, well, you can do malingering, but only if it relates to antisocial personality, not to something else. Clearly, he put his mental state in evidence. Everything would be fair game, whether or not we do it or not, whether or not we choose to enter that testimony. And that's my next argument, Your Honor. The defense can't just file a motion in limine and say, Judge, tell the state what witnesses they can call and what the witnesses can testify to. How on earth would the court do that, first of all? They have the ability to make objections during the trial as to cumulative evidence, whether or not it properly rebuts. It's not something that the court could possibly rule without hearing the testimony. I want to cite some cases to the court so that the court has some additional guidance. And I'd cite to the court Gutierrez versus Vargas. It is a Supreme Court of Florida case, 239 Southern 3rd 615, a March 22nd, 2018 decision. And in this case, they cite a 4th District Court of Appeal decision. If the court would indulge me reading this section, I think it's very important. In Delgado, D-E-L-G-A-R-D-O, the 4th District Court of Appeal determined the testimony of one orthopedic surgeon was not cumulative to the testimony of a second orthopedic surgeon, both of whom had treated the plaintiff. And that's at 731 Southern 2nd at 11 and 12. The trial court had not entered a pretrial order limiting each side to one expert per specialty. Instead, the district court reviewed a trial court's order granting a new trial on the grounds that the testimony of the two surgeons was cumulative and repetitive. In holding that the testimony of the two surgeons was not cumulative, the 4th District explained, while two proposed witnesses of the same medical specialty might indicate the possibility of cumulative evidence, the real question is whether they will testify to cumulative opinions based on the same facts. Clearly, a party is not necessarily guilty of calling duplicative witnesses simply because she calls two witnesses of the same medical specialty. The testimony of the second surgeon in this case establishes rather clearly that his evidence was based in part on the same facts and evidence as the first, but also in part on new facts and evidence. Therefore, as a matter of law, it was not cumulative. So we have the defense argument that, well, Dr. Scott, who is an eminent psychiatrist who examined the defendant, he has his examination of the defendant. Dr. Denny, a neuropsychologist, he examined the defendant, and he has his examination and his facts. They can rely on each other, but each has additional facts that they bring to their own examinations. It's just because he's a medical doctor as well doesn't mean he's limited to the FASD characteristics of the defendant's lip. I mean, that argument simply does not fly. The court would have to listen to all the testimony before it can make its determination. The defense has somehow, and I anticipate they're going to say, well, Your Honor, you limited the state to 2 different doctors to examine the defendant, and therefore, I don't know, they're trying to make that argument in writing in their motion that somehow limits how many experts we can call to the stand. One does not matter to the other. How many experts could examine the defendant has absolutely nothing to do with how many experts can testify in the court, as long as it's not needlessly cumulative. I can just have one moment to make sure I've addressed all of their notes here.
Sure.
I did not, they only had a Albert Perry on it. Thank you. The same would go for the psychologist. The court could not make that decision until they heard from the psychologist. To the extent that this motion just restates about cumulative evidence, the state is aware of that. But rebuttal is not merely as the defense suggests. Your Honor, for all those reasons, the state would ask that both motions be denied. Thank you, Your Honor.
Thank you. All right, I'm going to take all of the matters that I heard today under advisement. I'll try to have an order by tomorrow. And Mr. Marcus, I just wanted to make sure, I got the site, but I don't know that I got the name. Is it Gutierrez versus Vargas,
Yes.
239 Southern 3rd 615?
Yes, and then I quoted from that case Delgado at 731 Southern 2nd, 11 through 12, before DCA. That's at headnote 15, if Your Honor.
Okay, thank you.
Judge, can I just briefly respond?
Sure.
Okay. With respect to the motion to strike Dr. Ferguson, there's a big difference between having a neighbor come in and talk about him playing violent video games, and a principal and a teacher who is not a psychologist, who's not an expert, who said in a record that the state has been in possession of for months and months, and yet didn't find it compelling to hire and list this witness, that I sometimes wondered if he knew the difference between violent video games and reality. There was no defense expert, and not even these other witnesses, who are simply lay witnesses that just observed that he watched violent video games. No defense expert said that this offense was in any way committed but because he played violent video games. So that is not rebuttal to anything that the defense has said. And when I said a moment ago that this list may not be exhaustive, and Mr. Marcus's response is we have to guess, they don't have to guess. I said it was not exhaustive because this is based on our 3.202 notice and my recollection of what we presented during the trial. It's not that they have to guess. They were there. Everything has come out from the defense. The defense rested its case. There isn't going to be any more mitigation presented in the defendant's case. So they don't have to guess. It's just I may not have included every single thing that came out in this motion. Judge, if the court is going to allow Dr. Ferguson to testify, then we're asking that the court order that they make him available sooner than Friday for deposition. And if not, we're asking that the court order that he not be permitted to testify until we are given a fair and full opportunity to litigate any necessary issues regarding his testimony. Thank you.
Thank you. Is there anything else for today?
No, nothing to say.
Good. Well, I'll have those orders too as soon as I can get them done. And other than that, we're in recess. I'll see you all Tuesday at 9 o'clock.
Okay, so Gail, basically the defense wants to limit the state's rebuttal because they say they want to make sure that the witnesses actually address the mitigating circumstances that they presented, which seems reasonable.
Of course, because we all know that it's true rebuttal, just like in a debate, it has to be something that was stated by the defense for them to rebut.
So you can't rebut something that's not there.
Correct. You can't like say, hold something back and say, oh, by the way, we have this great piece of evidence. You can't get a Perry Mason moment on that. The problem is that they limited themselves by only calling 25 witnesses. So now they feel, well, we don't want a whole bunch of state witnesses because we only have one person that says each thing, and we think the state should only be allowed to have one person that rebuts each thing. And what the state said was, no, we're going to have witnesses that rebut it in all different ways, from all different sides, because our witnesses are looking at different types of evidence to come to possibly the same conclusion that the defense's witnesses were wrong.
But the defense is arguing, though, that there are, for example, too many psychologists. Why do you need all these psychologists saying the same thing?
Because each psychologist may have looked at something different or relied upon something different to come upon their opinion, which may change a juror's vote. So a juror might say, well, gee, the alcohol fetal syndrome is a problem, and one psychologist may say, no, it doesn't exist. The other one may say, it does exist, but it doesn't exist in that manner. And they maybe say, okay, I like what that doctor says, and I agree with that doctor, so I'm not going to consider that syndrome.
It's interesting because it's giving us a window into what the state might do in its rebuttal. For example, that the shooter had antisocial personality disorder or borderline personality disorder. They said he was malingering, which means he's faking it. Is that
right.
what that means?
That word is often thought that he's dragged it out. No, it means he fakes. And what happened was, it sounds like he faked hearing voices. And so they say, well, we didn't bring up the fact that he was schizophrenic. So you shouldn't be able to say that he faked hearing voices. And what the prosecutor, Mr. Marcus, said was, no, we can say he's a faker, and because he's faked, you can assume he's faking lots of other stuff.
One other thing that they want to do is they want to strike one witness, Dr. Ferguson, who's an expert in video games. So we might hear him say something like, there's no link between video games and this violent action. And the defense said, well, none of our witnesses ever made that link, and they're not wrong about that.
Well, what they did in their motion was, because we had the chance to read it, they set out what they thought the mitigation was, and they left that out, the video games. But they also said in their motion, this isn't a complete list. So what the prosecutor said was, listen, I can cite 4 witnesses that made reference to the video games, that he was very enthralled with video games, and they could come back in their closing and say, think about the video games. We want to stop that. We want to stop that before they get to say it. And we have an expert that's going to say that's a bunch of malarkey.
So all of this is going to happen next week, starting on Tuesday at 9 a.m. The state gets their chance to present these witnesses. Will they be limited? We don't know. The judge is going to rule on that, so we'll find out. Christina Vasquez, you've got to follow her on social media, and of course, watch Local 10 this week, and you'll find out more. And the question is going to be, once the closing arguments are made, and that may be the week of October 10th, this jury, how long do you think they're going to be out?
I think maybe 3 to 5 days.
You think it'll be that quick?
I don't think that's quick at all. I think that's really long.
You do?
Yeah.
For a case this complicated with this many victims?
Yes, because they will get an instruction that says they can take 1 vote. And if somebody just says, no matter what you say, I'm not going to vote death, the case is over.
So all it takes is one person to look at this, to say, I think that this shooter should be either shown some mercy, or some of these mitigating circumstances outweigh the aggravators that the state presented. Or some people might just have that gut feeling. As much as you're supposed to weigh the evidence, doesn't it a lot of the time? I mean, you've tried so many of these cases.
It's the one-man veto. It's the one-juror veto. It's the only time in American jurisprudence where one person gets to make a decision that affects everyone else.
And that's why everybody is watching this so closely. Gail Levine, thank you so much for your analysis, as always. We will be back Tuesday, 9 a.m., when the state presents its rebuttal witnesses. We'll see you then.
Thank you.